This paper came about because Mark Robinson, SC, who's one of the premier administrative law silks in Sydney, and I decided that we'd write a paper together. True to form, I'm the junior barrister, so it meant I wrote the paper, although we will present it. This paper here is a slightly polished up version of the draft that I've submitted to Mark. So it's far from complete. Obviously he's going to have significant input into my thoughts as they're expressed in this paper before we come up with a finished product. But certainly the issues that the paper raises are very important, I think, for the contemporary practice of administrative law. Why? It's because administrative law ultimately is all about the separation of powers and nothing else. The courts will not, and arguably cannot, trespass on the right of the executive to make decisions that are within the power of the executive to make. All a court can do on judicial review is ensure that in making the decision maker has followed the correct procedure. But of course, that has nothing to do with assessing whether the decision maker came out with a satisfactory decision according to the view of the judicial officer who's looking at the decision. We're all thoroughly familiar with the idea that in practice what that means is that the courts cannot engage in merits review. They can't engage in review of the findings of fact that the decision maker made, no matter how frankly bizarre, particularly in refugee cases, some of those findings of fact may be. Up until now, with one exception, which I'll talk to in a moment, we have been limited to challenging such decisions for errors of procedure, failing to take a relevant consideration into account or taking a irrelevant decision into account and so forth. The one exception, of course, has always been the decision in Associated Provincial Picture Houses in Wednesbury Corporation, which once again you'll all be familiar with. Some of you might be a bit less familiar with the fact that the plea failed in Wednesbury. The facts were actually very simple. A picture house was applying to be able to show movies on a Sunday in England. And the decision maker said, no, you can't. You know, Sunday, it's the Sabbath, and, you know, we don't engage in, you know, such low activities as, you know, going to the movies and having a good laugh on the Lord's Day. So in desperation, it was argued, well, look, you know, it's 1948, you know, we've just sort of fought a war for, you know, things like freedom and liberty. Really, times have moved on. Isn't it reasonable, you know, for someone, if they choose, to go and see, you know, Fred Astaire on a Sunday? And that argument was characterised as, look, where a decision, sort of according to contemporary standards, I suppose we can put in brackets, is so unreasonable that no reasonable decision maker could make it, then it's liable to be quashed. But of course what that's doing is it's focusing attention on the outcome of the decision. The entire attention in Wednesbury is being focused on the outcome, which is no, a movie house can't open on a Sunday. And in that particular case, the plea failed. The judge said quite clearly that they were all he's in those days, the judge said quite clearly that he didn't agree with the decision. He thought it was frankly, a quite silly decision, but the decision was within the range of decisions the outcome was within the range of outcomes that were available to the decision maker. He wasn't going to get in the way of it. End of the story. So Wednesbury has always been treated really as a plea of last resort. If a judge sees that you've got so unreasonable that no reasonable decision maker would make the decision, the judge knows that you're desperate. And he's always, or she has already made sort of mental note to down the plaintiff and award costs. It's a very high bar. In England and Wales, the test of Wednesbury has been objectively so devoid of any plausible justification that no reasonable body of persons could have reached it, or alternatively absurd. Now, my understanding is that in Australia it's generally been absurd. You've got to show that the decision is absurd, and it's very difficult to get up on that basis. Pico Wallsend, which of course is famous for emphasising that a decision maker is only bound to take must only take a consideration into account that he or she is bound to take into account. That's what we know that case for. But it also says quite a lot about Wednesbury unreasonableness, and it does talk about a plea of Wednesbury unreasonableness giving you scope to talk about whether or not the decision maker is given proper weight to certain factors within the decision, which is sounding suspiciously like appealing a discretionary decision of a judge. That was the state of play until basically the turn of the millennium. In 2003, there was quite a well-known case that created a lot of excitement at the time, which is known by one and all as S20, which I've written about in the paper. The facts of this were that the decision maker did not believe the refugee. There was no surprise in that. None of them ever believe the refugees when they tell their stories. The unusual aspect of this particular decision was that a reasonably independent witness who actually had been a member of the military in the country from which the applicant was fleeing gave evidence supporting the applicant's story. And the decision maker said, I don't believe the applicant. I think he's a complete liar. That must mean that this witness is lying as well, because if I don't believe the applicant and this witness is giving testimony that is consistent with what the applicant has said, then I don't believe the witness either, and threw it out. This went to the High Court. The interesting thing is that the Migration Act at the time forbade reliance on Wednesbury unreasonableness. You could not raise it challenging a decision in the Refugee Review Tribunal at the time. So what was raised was illogicality and irrationality of decision. You're saying, well, look, it's completely illogical and irrational simply because you don't like, the applicant very much, to completely throw out, the evidence of, a pretty cogent witness, simply because that witness supports its story. And the outcome of that, of course, was that the High Court said, no, it's not illogical or irrational. It's open to the administrator or the administrative decision maker to do that. So in that particular case, the High Court accepted that irrationality and illogicality was a ground or a plea, if you like, that could be raised. But on the particular facts in front of the court, which, you know, were pretty good facts, I would have thought, for the appellant, the court said, but we don't find that the conduct of the decision maker was illogical or irrational. Which of course raises the question, okay, well, the High Court accepted the ground, but if you can't make out the ground on those facts, when are you ever going to make out that ground? The ground of illogicality and irrationality was then considered again in SLGB. Now, the critical difference between SLGB and S20 is that what was at play was a jurisdictional fact. Now, the difference between, for an administrative lawyer, between a fact and a jurisdictional fact is that a jurisdictional fact is something that must be found to the satisfaction very often. There can be other wording, but most often something that is found that must exist to the satisfaction of the decision maker before the decision maker's discretion is enlivened. All right. And so what was quite simply said in SLGB, that in the, if you like, not finding the jurisdictional fact enlivening the decision maker's discretion, that that the decision was illogical and irrational and couldn't stand, and it was bad for jurisdictional error. SZMDS, well, I should just interpolate that at that point we are still feeling quite safe because we can understand what's happening. We can understand that Wednesbury unreasonableness is still the only way that we have, essentially, of attacking the outcome of a decision. Illogicality and irrationality remains a method of attacking the procedure and only the procedure. The problem is that illogicality and irrationality was considered again in Minister for Immigration and Citizenship and SZMDS. And the court split on whether illogicality and irrationality sounded only for an error in procedure, or whether it could also sound for an illogical and irrational outcome. So the question was raised in terms of what the High Court seemed to be saying is that it was considering broadening, particularly in the area of jurisdictional facts, the ability of the court to consider the outcome when deciding if a plea of illogicality and irrationality would succeed. But it never truly resolved that issue. And that leads us to the case which you're all here to listen about, which is the case of Lee. And the facts are very simple. Lee was applying, she wasn't a refugee, I think she was applying for a visa as a migrant, and it relied on her abilities as a cook, as a chef. And she undertook 2 tests of her abilities as a chef. She passed one, but failed the other. She challenged the second finding, the second failure. All right. But before that challenge had been decided, she was dragged back in front of the Migration Tribunal, which said, no, Ms. Lee, you've had more than enough time to fulfil the criteria for your migration visa. I'm not going to give you your migration visa. So this went on appeal, or should I say review, to the High Court, where the issue was, of course, a failure to grant an adjournment. I mean, the natural, we would all understand, having been in practice, that under those circumstances where there is a, contested finding, that a person should at least have a chance to sort that out before having their, fate ultimately decided. But the tribunal didn't do that, but denied the visa without granting an adjournment. The approach of French was quite interesting. And I'm not quite sure how he managed to do this, but he actually found that it was a denial of procedural fairness. And while that might seem obvious to all of us, in the Migration Act, procedural fairness is codified. And if you can't point to an aspect of codification of procedural fairness in the Migration Act, you're not going to be able to bring procedural fairness as a ground to have the decision quashed. And he still managed to be able to say, no, it's a denial of fairness, procedural fairness at common law, and it should be quashed for that reason alone. So it's an interesting decision on that basis, if for nothing else. And he also said, look, it's Wednesbury unreasonable. It's so unreasonable not to give an adjournment in these circumstances that no reasonable decision maker should have done it. But that's not really what the excitement about the case is all about. The excitement is about the plurality, which stated this at paragraphs 63 and 68. In the case of a discretionary decision, there is a presumption of law that the discretionary power will be exercised reasonably, and that the legal standard of unreasonableness is not limited to Wednesbury unreasonableness. So what they're saying is that Wednesbury is not the only way that you can challenge the outcome of a decision. And what was also interesting is they actually agreed with Justice Mason, as he then was in Pico Wallsend, and said, look, challenging a decision for jurisdictional error is very, very similar to making an application on the principles of House and King. And so the High Court is sort of expressly saying that. Well, what does this decision sort of really stand for? Well, personally, I have no idea, but the full court of the Federal Court... It's a good paper. The full court of the Federal Court does have a very good idea what that decision was about. And it said this, and it's worth just sort of reading because I think it's really quite revolutionary. The full court of the Federal Court in 2014, talking about Lee, said this. It said that legal unreasonableness, which is this ground that was found by the High Court, is invariably fact-dependent. Wow. For an administrative lawyer, that's stunning. And it can attach to the unreasonableness of the process or the unreasonableness of the result, and that's what's truly revolutionary about this decision. Mark Robinson told me that Chief Justice Mason had told him that the decision in Lee was probably the most important decision made by the High Court in the last 10 or 20 years, certainly in the field of administrative law. So you can challenge, it is possible to challenge an administrative decision for the unreasonableness of the result. And the court seems to sort of reconcile SZMDS. This is the one where the court split. Well, you can get a remedy if you can show irrationality of procedure, or maybe you can get a remedy if the outcome is irrational. I think they solved that conundrum very neatly by simply saying, well, look, some decisions are supported by reasons and some aren't. Doesn't mean you can't undo the decisions that are not supported by reasons. All you can say is that on its face and all of the circumstances known to us, that decision is bad. Legal unreasonableness can be a conclusion reached by supervising courts after the identification of an underlying jurisdictional error in the decision-making process. However, legal unreasonableness can also be outcome focused without necessarily identifying another underlying jurisdictional error. Once again, that's revolutionary. The courts have time and time again said, look, if you are pleading Wednesbury unreasonableness, all that really means is that you're not clever enough to have been able to spot the procedural error that has given rise to this seemingly unreasonable result. And the High Court is resiling from that. They're saying you don't have to necessarily identify another underlying jurisdictional error. In circumstances where no reasons for the exercise of power or for a decision are produced, all a supervising court can do is focus on the outcome of the exercise of power in the factual context presented and assess for itself its justification or intelligibility, and so forth. That decision in Singh was essentially followed by the full court of the Federal Court in Stratton 2016. And it's actually worth going to Stratton because Stratton actually sort of in dot point form summarises Singh, which of course tells you what Lee is all about. And also in Stratton, the full Federal Court was really at pains to say, look, this is not, this is not open slather. The court's role remains strictly supervisory. It is concerned with determining whether there has been a lawful exercise of power, having regard in particular to the terms, scope and purpose of the statute conferring the power. In circumstances where reasonable minds might differ about the outcome of or justification for the exercise of power, or where the outcome falls within the range of legally and factually justifiable outcomes, the exercise of power is not legally unreasonable simply because the court disagrees, even emphatically, with the outcome or justification. If there is an evident, transparent and intelligible justification for the decision, or if the decision is within the area of decisional freedom of the decision maker, it would be an error for the court to overturn the decision simply on the basis that it disagrees with it. But it's also giving you a hint, okay, that if it is arguable that the decision was not transparent, if there wasn't evident reasons for the decision, or an intelligible justification that you might have legal unreasonableness on your hands. The paper, as I've drafted it, goes on to talk about proportionality. Personally, despite the best efforts of their honours in the full court, I'm not convinced that legal unreasonableness is as principled as they say it is. I think, for the next little while at least, it's going to be very fluid about what sort of arguments the courts are going to accept and what they're not going to accept. The second part of the paper talks about the principle of proportionality, which is a civil law doctrine, which is basically saying, look, is the administrative decision proportional given the public policy to which that decision is giving vent to, and given the effect that that decision is going to have on the individual. It's become a big talking point in the UK because after the UK had to accept the Human Rights Act, the European Human Rights Act, after that became part of the domestic law of the United Kingdom, it also had to accept that proportionality was part of British law in order to sort of decide the sort of human rights questions that were brought up under the Act. We, of course, in Australia, we don't have human rights legislation. There's something in Victoria which I don't know much about. But the point about proportionality is that it seems to me that we have legal unreasonableness which is not terribly well defined. You know, at what point does the decision maker's discretion so that it tips over to being unreasonable? We're not really sure about that. We do seem to have a principle of proportionality which has been out in the ether for quite a while as being potentially applicable to the determination of administrative law decisions. And it's certainly part of the determination of administrative law decisions in the United Kingdom, in Canada, and apparently in New Zealand as well, where they have human rights legislation. But in Australia, it is not part of administrative law. It is certainly part of constitutional law, where the proportionality principle is used to gauge the relationship between a purpose of power under Section 51 and a law relying on that power, but it's not part of our administrative law yet. The current academic thinking is that it's not going to be part of our administrative law because we don't have human rights legislation, and therefore you sort of try to fit a round peg into a square hole in the absence of any such legislation. However, when you read the last couple of paragraphs of the paper, you'll see that not only does the High Court in Lee itself, both the Chief Justice and the plurality, canvass the possibility of applying proportionality, but also Kirby, His Honour Justice Kirby, I think one of the better administrative lawyers that Australia has ever had, wrote an entire obit of judgment relying on the proportionality principle. And Singh said in its final decision, it applied legal unreasonableness and looked at the scope of the statute and all that sort of thing in coming to its decision. And then in the very last paragraph of the decision said, look, if the proportionality principle had applied, we would have come to the same outcome. So it's out there. Academics think, no, we're not going to have it without human rights legislation, but some pretty eminent judges seem to be saying you can apply this on the ordinary principles of administrative law, and that's what the paper is about. And thank you for your kind attention.